Well, Jimmy Ellis filed a writ of prohibition against the county commissioners, the county auditor, and the treasurer to stop payment of salaries to anyone that cannot produce lawful authority to receive public money. Under 3617, only officers and employees are entitled to receive money from the public treasury. And officers has a specific definition that is a person authorized by law. It comes under 116.065, and the Supreme Court has ruled on it at least 5 times in the leading case of McIntosh versus Hutchins. It requires the oath to be taken and filed. The legislature also went as far as to define the definition of filing, recording, and record location number twice in the RCW, under 3618.005 and 6504.015. And they even included under 6504.040 the exact procedure that the auditor or recording officer, whether it's the state or the county, is supposed to take documents and make them part of the historical public record as the oath of office has been defined by the State Records Commission. The purpose of it is it eliminates fraud. The statute of frauds was created for this because all the oaths of office are supposed to be given a book number and a record number and everything when they're submitted to the auditor in the sequence in which they come into his office. What Stevens County and the state of Washington do is use a regular hand stamp that the date can be changed at any time, for any position they want it to. So a so-called government official can go in and have an oath backdated and to cover his butt.
Okay, Jimmy, did the judge there today, Judge Tompkins, is she lawfully seated as a lawful judicial officer?
Well, in my paperwork, I demanded that because of the jurisdictional issue involved in this and what it involves, and because it created a conflict of interest, that she produce, or any judge that was assigned to the case, produce a copy of their lawful oath of office and file it into the official proceedings. She flat refused to do that and would not even address it. But when she refused to address the issue on the records, she lost all of her civil immunity, which is also illegal. That the judges claim absolute civil immunity, but when they act totally without jurisdiction, they have no immunity. All right, but the cases involved, now the RCWs under 716.320, the annotated case law states specifically that if the opposing party or the defendants do not respond, then they are not supposed to even be allowed to participate. That the court is supposed to rule strictly on the contents of my writ, and I covered everything in it, and showing that the oath is mandatory and it has to pay the fee and all that. So she's trying to overrule Supreme Court rulings when she ruled that the filing fee was not required.
Okay, when did you file this writ, and when did you receive a response from the...
It was initially given to Evelyn Bell, I believe it was on April the 3rd. So it's almost a month that they stalled it. They kept giving me the runaround and everything on it, and then the first Judge Price from Spokane was assigned to it. He kept giving me the runaround, so I sent him a notice of jury tampering, witness tampering, and so all of a sudden it got approved, and he recused himself from the hearing because I'd also sent him a second letter demanding a copy of his oath of office, and he can't produce it. There's not a judge in Spokane, or well, in the state yet, like I told the state court, there's not a judge in this state that's in office legally. And so when she walked out, now she claims that I didn't quote the laws. I quoted at least 20 different laws in there and case laws supported right out of their law books. Now the prosecutor's office, Nick Forrest and all, I've already informed Mr. Radney for several years now that he doesn't have an oath of office, and in his paperwork that he submitted, he put in 3627.040, which requires deputy prosecutors to have a written appointment from the prosecutor and be filed into the auditor's office, and that means that they got to pay a filing fee for it.
Okay, when did you receive that paperwork from Nick Forrest, the deputy prosecutor?
Yeah, his so-called response came in as he delivered it in the courtroom today, and he admitted on the record he didn't even mail it till past Friday. But now under the court rules, he only had 20 days to respond to the day of service. Now, there is an affidavit of service in there by Roy Yeager, the independent party, where he served the county commissioners, Tim Gray, and Susan Harnasch. But as far as claims, that's the only one they got. That just shows more of their incompetence. They can't even keep track, their case law. And but it's just when the government has gotten so corrupt and incompetent as it is here, that the Constitution no longer applies to them. The my Constitution still applies.
Do you think that the decision today, as improper and illegal as it may be, do you think it was determined on the merits that she heard today, or predetermined?
No, everything was predetermined to start with, but the thing is, she stated, I didn't quote any laws, but yet she couldn't quote any laws. So I asked her, which laws she was relying on, and she could not quote any law. Plus, when she walked out of the courtroom, she stated that she was making a ruling pursuant to State versus Stevenson, 1998 appeals court from the Second Division of the appeal court, in which I had already stated on the record there that I had the case and it was null and void, and it's an appeal court case that cannot overrule the Supreme Court. Further, I was going to go ahead and address the so-called Attorney General's opinion that they, of course, included in his paperwork. Now, it was actually stated on the opinion that it was not an official opinion. There's a guy named Jeffrey Evans from the Attorney General's office, which has no oath of office either. Now, in his remarks, he quotes Lyons versus Ruff and everything else, but I had already submitted Attorney General's official opinion from 1980, number 2, and Attorney General's opinion from 1963-64, number 17, that stated that Lyons versus Ruff was no longer valid, and in Vanderveer versus Rumley from 1909 overturned it. It also ruled on the issue under 4212.010, subsection 6, that all the offices are automatically vacant when they fail to deposit their oath as required by law. Now, that case is covered by the Attorney Generals and everything, and State XL Austin ruled on that, the United States Supreme Court. And they stated specifically that if they fail to comply with any of the elements within that, then that office is vacant, and it takes no judicial process to vacate the office.
How many judges in Washington at any level are you aware of that have actually properly incorporated their oaths of office into the official public record?
So far I found none. Now, originally when Judge White, district court, so-called judge, when she was appointed to take Judge Payne's place, now she actually recorded her initial oath of office after the appointment, but yet after the election, she failed to pay the filing fee and have it recorded. And I've got an email response from the state auditor's office, because the state auditor is supposed to come in and audit the county every 3 years. And they're supposed to make sure that every dime is accounted for, the laws and the Constitution are complied with. Now, they actually state that when they come in, they don't check the oath of office. And I asked them, their inspector, they tried to keep talking to me, but I called her. They called me the day she was here, and I stopped and came on in. And I asked her about it, because without verifying the oath of office, there's no way to know if the people receiving the paychecks are girlfriends, boyfriends, or something else from any official out here. There's no way to support their claim. And she just said, well, we don't check it. But that's not what their duties state, because in 2005, there was an initiative on the ballot that was approved. It was Initiative 900. It's now under 4388-160, the RCWs. About 4 pages long in the RCWs, defining the duties of the state auditor as it relates to doing their audit of the county and the state. And but yet it's totally ignored, and that's the problem. The government is no longer a government of the people. We have a bunch of incompetent, corrupt people, and we've allowed the Bar Association to take over the country's problem. And in fact, in this state, most people don't realize it, but the Bar Association is a private, for-profit organization, but yet they were made an agency of the judicial branch of government June the 7th, 1933. And they control all the colleges and everything and what's being taught, not the state. And but they're tax exempt and they can't be sued, without their permission. Yeah, all of this has been turned completely around from what it's supposed to be.
So, Mr. Clark, where do you go from here?
Well, I've already been to the Attorney General's office. I'm going to go ahead, probably just go ahead and move it on up and do a motion to vacate under 60B5 for a total lack of jurisdiction. Because when the judge refused to address it on the jurisdictional issue on the record, she lost all jurisdiction. So her ruling is nothing more than, in fact, when she files her paperwork, it will actually be a violation of 4016-030, filing false or forged documents into the public records, which is a Class B felony. And under the case law on that one, it doesn't even require intent. Right. She filed it. So.
Hey, my name's Connie LaRue. I'm in Stevens County, Washington today, and we just came out of the courtroom and we listened to a delightfully intelligent presentation by Jimmy Clark, Mr. Jimmy Clark. I have never heard anyone, not even an attorney, who can talk to a judge and make a presentation like Jimmy Clark did today. He can cite, he can tell you the laws, he can cite case law, and he can just make the most beautiful presentation for 30 minutes non-stop. And I don't even know, and without even any notes even, and I don't know an attorney who could do a thing like that. And Jimmy just did a great job. The courtroom in itself, I thought, was very poorly done. Jimmy was having difficulty hearing what the judge was saying, and what are they, 12 feet apart? And the judge had a microphone but wouldn't use it, right? And I was sitting the first row behind Jimmy. I couldn't hear what Jimmy was saying. I couldn't hear what the judge was saying. Very poorly done. Yeah. But Jimmy did a great job, and thank you for that.
You think she was impartial?
Was she impartial? No. She was as partial as she could be. And it's a terrible thing when the judge has predetermined before she walks into the courtroom what her outcome is going to be here. It's a terrible thing.